Casey Ashmore, back in the studio with you, doing a deep dive into Texas family law. And in this video series, I'm going to keep explaining the difference between protective orders and restraining orders, and what the injunctions that are granted in each order and why they're different. And just so we're clear on legalese, injunctions means conduct that is prohibited by court order. Before I do that, it would be remiss for me not to acknowledge the turmoil in our country, both from the crushing economic upheaval of the coronavirus pandemic, as well as the death of Mr. Floyd in Minnesota. We are praying for all of our neighbors and countrymen, especially those of our neighbors and countrymen who are African American, and we are listening. The Texas Family Code provides for several types of hearings without the other party. Those are called ex parte hearings, and these ex parte hearings involve Texas family law temporary protective orders and temporary restraining orders. So we're going to go back to the protective order. At the end of the protective order hearing, the judge has a few options. If the judge makes a finding that there's good cause that family violence occurred or may have occurred, she can grant a protective order excluding the alleged abuser for 24 months from the family. And that means no visitation with the children, no visitation with the other spouse, no contact for up to 24 months. So there's a lot at risk in a protective order hearing. In a temporary restraining order hearing, the judge can make that a temporary injunction at the conclusion of that hearing and issue an order that prohibits a whole laundry list of behavior disturbing the peace of the other spouse or the children, draining bank accounts, requiring a party who has drained bank accounts to replenish them or return money to the other side, things of that nature. It doesn't rise to the level of the family violence allegations. But again, both these hearings and the results can be extremely dangerous. And another thing that can happen is that the court can, in both these situations, make determinations as to what's in the best health, safety, welfare of the child, make a best interest determination, and either set out a parenting plan because the parents can't agree on one. So they're going to be visitation on a plan that the court, whether that's going to be supervised. Parents can be required to be supervised by their family members, or in situations where the allegations are serious or more serious, by third parties like Hannah's House, or sometimes even CPS officers and agents. So the visitation occurs at essentially in a law enforcement environment. So these are some serious and can feel draconian, but they are there to protect the health, safety, welfare of the children while things occur, to determine and really allow the court to dig into the merits of the allegations that are being made. And because they're temporary, they're permitted under constitutional law, they're permitted under our state constitutional law, and that's one of the reasons why these orders can be granted by the courts, and there's not a whole lot a citizen can do about it. The court makes findings and proceeds, in my experience, with extreme caution regarding these allegations. And it's not only there to protect both parents from the allegations, but also to allow third parties to come in and assist the court determine the merits of those allegations. I'll get into more of that in the next video segment, but thank you for watching. I hope that you find these video series helpful, positive, uplifting, informational. That is what they are intended to be. Please like, subscribe, and share. Leave me a comment on any video platform you may watch this on, LinkedIn, YouTube, etc., and I will direct message back to you or make that comment the subject of a subsequent series. Thank you so much for watching. I'll see y'all in the studio for more on Texas family law.